when it comes to suspensive condition, when the acquisition of right or the existence of obligations, again, when the acquisition of rights or the existence of obligations is made to depend upon the fulfillment of the condition, then it is a suspensive condition. Again, when the acquisition of the rights or the existence of obligations is made to depend upon the existence or fulfillment of the condition, then therefore it is a suspensive condition. These are two. If suspensive condition is fulfilled, then the obligation arises. While if the suspensive condition does not take place, then therefore the parties would stand as if the condition never had existed. During the pendency of the condition, no obligation yet. Yes, that's during the pendency of the condition. For suspensive condition, um, when the acquisition of the rights or the existence of the obligations depend upon the fulfillment of the condition, then that's a suspensive condition. During the pendency of the condition, then there is no obligation yet. The obligation does not arise yet. No obligation yet. The obligation does not rise yet. Hence, it cannot be demanded. The debtor may, therefore, pending the fulfillment of a suspensive condition, recover what during the same time he has paid by mistake. So, more examples. In which under Article 1179, every obligation whose performance does not depend upon a future or uncertain event. If we say future and uncertain event, that is condition. Future or uncertain event. Upon a past event unknown to the parties is demandable at once. Again, every obligation whose performance does not depend upon a future or uncertain event. If we say future and uncertain event, that is condition. Or upon a past event unknown to the parties, then it is demandable at once. So this first paragraph is the definition of resolutory condition. Demandable at once. Ba? Every obligation whose performance does not depend upon a future or uncertain event or past event unknown to the parties, then it is demandable at once. While every obligation which contains a resolutory condition shall be demandable at once. So again, the paragraph 1 is a resolutory condition wherein it is demandable at once without prejudice to the effects of the happening of the event. So again, as a review, wherein pure obligation, if we say pure obligation, it is subject to no condition. It is an obligation without a condition or term or period. Hence, demandable at once, provided there will be no absurdity. Example, I promise to pay you 1 million pesos. This is demandable at once. I promise to pay, subject to no condition, so pure obligation. If it is a pure obligation, demandable at once. Again, every obligation whose performance does not depend upon a future or uncertain event or past events unknown to the parties is demandable at once, then that is pure obligation. Unless I promise to pay you 1 million pesos, demandable at once, unless a period was really intended, as when a loan has just been contracted. So it is obviously it is a contract of loan, and it is in by nature it needs a period to pay. Next, I'll pay you 1 million pesos on demand. So whenever the creditor demand, that's the time the debtor will pay the 1 million pesos. But instant performance is not a necessity. Otherwise, absurd consequences will arise. So this is already, diba? Every obligation contains a resolutory condition. Every obligation contains a resolutory condition shall be demandable at once without prejudice to the effects of the happening of the event. So I will pay you, the debtor will pay 1 million pesos to the creditor, but instant performance is not a necessity, otherwise it is absurdity. Diba? But instant performance is not a necessity. It's not a necessity. Otherwise, absurd consequences will arise. When the original period or condition has been cancelled by the mutual stipulation of both parties. So therefore, period and the term has been cancelled. Therefore, the obligation is already subject to pure condition. A pure obligation rather, subject to no condition, then demandable at once. Again, for conditional, the opposite for pure obligation is conditional obligation. Example, I will buy your land for 10 million pesos if you pass the last bar examinations. This is suspensive for the results will be awaited. So this is a suspensive condition, di ba? I will I will buy I will buy your land for 10 million pesos if you will pass the last bar examination. So this is a suspensive condition because the condition here is the result from a bar examination. If the suspensive condition is fulfilled, then the obligation to buy the land arises. If the suspensive condition did not fulfill, so therefore the parties would stand as if the condition was never existed. I will give you my land now, but should you fail in the last bar examinations, your ownership will cease and it will be mine again. Again, I will give you my land now. I will give you my land now. But should you fail in the last bar examinations, your ownership will cease and it will be mine again. This is a resolutory because it ends up upon a failure. This resolutory condition is the opposite of suspensive condition. In resolutory condition, if the condition is fulfilled, the obligation extinguishes. Diba? I will give you my land now. Yes, I will give you my land now, but if you fail the last bar examinations, the land will be mine again. Again, the definition of condition is uncertain event which wields an influence on legal relationship. That's a condition, that's uncertain event. While term or period, that which necessarily must come. Term or period, which that which necessarily must come, like 2005, whether the parties know when it will happen or not, like death. If we say death is a condition, it can be a condition, future or uncertain, because condition, it is future that it will happen, diba? In the future may happen, but the arrival of the period is uncertain. But if death is certain, then therefore it is already term or period. Death is already considered as term or period. Example, I will pay you 1 million pesos on June 1, 2005. So there is a period, June 1, 2005. When an obligation is demandable and at once, di ba? If we say demandable at once, so what are those obligations demandable at once? So from Article 1179, wherein every obligation whose every obligation whose performance does not depend upon a future or uncertain event, or a past uh, a past event unknown to the parties shall be demandable at once. So that is a pure condition. The very first is the pure condition, and the second one is the resolutory condition, wherein when when every obligation which contains resolutory condition shall also be demandable, without prejudice to the effect of the happening of the event. So example for resolutory condition, in which I will give you my car, but you should not marry Maria this year. So next year you can, but this year you must not, because that is a resolutory condition. This is demandable now. When it comes to resolutory condition, it is demandable now. Note, if the obligation is worded this way, I'll give you my car, but only after you can prove that by the end of this year, you have not married Maria. So, suspensive condition, ba? I will give you my car, but only after you can prove that by the end of this year, I will give you my car, but only after you can prove that by the end of this year, you have not married Maria. So that is a suspensive condition. If it is a suspensive condition, it must be worded like this: I will give you my car, but you should not marry Maria this year. Diba? That's a resolutory condition, demandable at once. I will give you my land now, but should you fail the last bar examination, your ownership will cease and the land will be mine again. Resolutor, demandable at once. The fulfillment of the condition extinguishes the obligation. Diba? Next, past event unknown to the parties. What do we mean by that? Past event unknown to the parties. This is not exactly a condition, since as a matter of reality, the thing has already happened or not. What is really meant here is future knowledge of a past event will determine whether or not an obligation will arise. Again, past event unknown to the parties is not exactly a condition, since as a matter of reality, the thing has already happened or not. Had already happened or not. That's a matter of reality. If we say past event unknown to the parties, it's a matter of reality, the thing has already happened or not. Next, classification of condition as a review. The first is suspensive condition and resolutory condition. If we say suspensive condition, it is subject, the fulfillment of the condition the obligation arises. While in resolutory condition rather, the fulfillment of the condition rather extinguishes the obligation. Again, for suspensive condition, fulfillment of the condition, the obligation arises. While in resolutory condition, when the condition is fulfilled, the obligation extinguishes. Potestative, casual, and mixed. If we say potestative, it's a condition depends upon the will of one. Depends upon the will of one of the parties. I will sell my car if you like, diba? Casual depends on chance or hazard. Casual. While mixed, partly potestative and partly casual. Divisible, capable of partial performance. Indivisible, it's not capable of partial performance because of the nature of the thing, because of the law, or in the intentions of the parties. If we say conjunctive condition and alternative, conjunctive, the obligation must be full, the condition must all, there must be compliance of all the conditions, diba? If all the conditions must be performed, that's conjunctive. But when it comes to alternative or injunctive, only few of the conditions to be formed. That's the opposite. Again, for conjunctive, the performance of all the conditions, it requires the performance of all the conditions, while for alternative, only few or only one of those conditions must be performed. Under Article 1180, when the debtor binds himself to pay when his means permit him to do so, so this is now where depends upon the will of the debtor. When the debtor binds himself, to pay when the means permit him to do so, the obligation shall be deemed to be one with a period, subject to the provisions of Article 1179. This Article 1180 is correlated with Article 1197, in which Article 1197, Article 1197, this is the law with, this is the article with a period. Under Article 1197, if the obligation does not fix a period, but from its nature, if the obligation does not fix a period, but from its nature and the circumstances, it can be inferred that a period was intended. The courts may fix the duration thereof. So, this is already the consequence of Article 1180, wherein in Article 1180, when the debtor binds himself pay, diba? When the debtor binds himself to pay when his means permit him to do so. So it means to say, when the debtor is able to pay, he will pay. But if he is not able to pay, or depends upon his will, he will not pay, then therefore, the consequence of that is Article 1197, diba? Shall be deemed. Then, again, when the debtor himself binds to pay, when means permit him to do so, the obligation shall be deemed one with a period, subject to the provision of Article 1197, wherein if the obligation does not specify an obligation, again, Article 1197, wherein if the obligation does not fix a period, but from its nature and the circumstances, it can be inferred that a period is intended. So the court may fix the duration thereof. So, go back. What do we mean by the phrase debtor to pay when his means permit? Debtor to pay when his means permit. Although it may seem that Article 1180 speaks of a condition dependent exclusively on the will of the debtor. So, this is a potestative obligation, Article 1180, potestative obligation wherein the tenor of the obligation is depend upon the will of the debtor, diba? Then it is apparently void under Article 1182. Speaks of a condition dependent exclusively on the will of the debtor. Again, Article 1180, when the obligation, when the debtor binds himself to pay when his means permit him to do so. Again, when the debtor binds himself to pay, when his means permit him to do so, it can be inferred the obligation shall be deemed with a period subject to the provisions of Article 1197, in which if the obligation does not fix a period, but from its nature and the circumstances, it can be inferred that a period that it can be a period that it can be inferred that a period was intended. So the courts may fix the duration thereof. So Article 1180 correlate it with Article 1197. So similar phrase again when when the condition depends upon the will, or conditions depend upon exclusively, the condition depends upon exclusively on the will of the debtor, then it is apparently void. These are similar phrases when debtor to pay when his means permit. Example, when my means permit to do so, when my means as a debtor permit to do so, where when I can afford it. Diba? I will pay. I will buy it when I can afford it. Depends upon the will of the debtor. When I am able, if you're, when I have money, diba? Though these are similar phrases. Next, how long is the term? Diba? Term, how long is, if we say term, it is certain. Certain. It is obvious that to leave the same to the discretion either creditor or debtor would be unjust. Being potestative, di ba? The will, the condition, when it comes to potestative condition, it is a condition depends upon the will of one of the parties. It can be either creditor or debtor. But when it comes to creditor, depends upon the will of the creditor, it's valid. But when it comes to conditions depends exclusively to the will of the debtor, then it is apparently void. Under Article 1197 should be applied where the court is obliged to fix the duration of the period. The general rule is, therefore, for the creditor to ask the court, the general rule is, therefore, for the creditor to ask the court first for the fixing of the term, and it is only when the term set arrives that he can demand fulfillment. Only from the arrival of the term or expiration of the term that the creditor can demand for payment, for fulfillment. Any action to recover before this is done to be considered premature. Again, when there is a period, the creditor, the very purpose of placing a period is to avoid instant action or instant payment. I will lend you 1 million pesos, then pay it by tomorrow. So that is an instant obligation. And also fixing a period or term is to set liability for the debtor in case of delay or damage. Collecting prior to the period is premature, diba? But the best collecting period for the creditor against the debtor is after the period. Any action to recover before this is done is considered, before this term is considered premature. In said patente case, this is from Tiglao et al. Versus Manila Railroad Corporation, 98 Philippines, Phil 181, wherein the phrase was as soon as possible or as soon as I have money. The only case when the bringing of the action to enforce, therefore, before the court fixes the term, would be allowed is when the prior action of fixing the term would serve no purpose but delay. Again, the phrase as soon as possible, ASAP, or as soon as I have money. The only case when the bringing of the action to enforce before the court fixes the term would be allowed is when the prior action of fixing of term would serve no purpose but delay. That is in Tiglao et al. Versus Manila Railroad. So again, action to recover prior to the set of term or period, it's premature. Article 1181. In conditional obligations. This is Article 1181. In conditional obligations, the acquisitions of rights or the existence of obligations depend upon the future or uncertain event or any or those events unknown to the parties. Does not depends upon the future, diba? Or uncertain event or upon a past event unknown to the parties is resolutory. Is demandable or resolutory conditions or pure obligations. In conditional obligations, the acquisition of rights as well as extinguishment or loss of those already acquired shall depend upon the happening of the event which constitutes the condition. So this is now suspensive condition. Article 1181. Article 1181, it's a conditional obligations, the acquisition of rights, the acquisition of rights, as well as the extinguishments or loss of those already acquired, diba? Shall depend upon the happening of the event which constitute the condition. So therefore, it is a suspensive condition. Suspensive conditions.